feel like remembers that transition.
Good morning. The House Judiciary Committee will come to order. Madam Clerk, will you please call the roll?
Chair Breen.
Present.
Representatives Edwards.
Present.
Carter.
Present.
Hope. Here. Arbit. Devendorf.
Here.
Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel.
Here.
Wozniak.
Here.
Outman.
Here.
Johnson.
Here.
Madam Chair, you have 12 members present. You do have a quorum.
Thank you. I will now take a motion from Representative T. Carter to approve and adopt the minutes from the previous meeting. Those are now adopted. Today, we will be hearing some riveting testimony on House Bills 4863 and 4864. My apologies to the committee for the late notice. We did have some other things lined up. However, life happened, and certain bills did not get sent over from the Senate, and certain witnesses were not available for testimony. So I anticipate that next week we will be taking up additional testimony on xylazine and drug immunity. But this week we have Representative Wozniak, who is, as well as Jim Spica, who are going to offer some testimony on House Bills 4863 and 64. Gentlemen, the floor is yours.
Morning, Chair. My fellow members of the committee, as a sponsor of House Bill 4864 and a co-sponsor of House Bill 4863, I sit before you this morning to request you support both of these bills, which provide technical fixes to Michigan's tax code as amended by Public Acts 145 and 154 of the last term. These acts ensure that Michigan-based trusts had the option to utilize a tool, commonly referred to as the Delaware tax trap, as first described in the April 1988 issue of the Journal of Taxation, as an affirmative planning tool to limit a trust exposure to federal generation skipping transfer, or GST tax. Since the passage of PAs 145 and 154 of 2022, the Probate and Estate Planning section of the State Bar of Michigan has identified two technical fixes they believe are needed to avoid the necessity for trust to move out of state. The goal of these bills is to make sure Michigan-based lending institutions and trust advisors remain attractive options for Michiganders seeking to establish trust. Last term, the bills passed both chambers with unanimous support, as should these bills, which are simple, if somewhat technical, fixes. To explain the necessity of this legislation in more detail, I would like to introduce Mr. James Spica, whose legal practice is dedicated to representing and advising individuals and institutions with respect to complex trust planning, and who is recognized for his accomplishments in developing trust law nationally as a Uniform Law Commissioner and American Bar Association advisors to the Commission. I would at this time like to turn the microphone over to Jim for further explanation. And if the chair wants, he'll go into the rule against perpetuities.
Thank you, Representative Wozniak. I am the principal author of the statute that the 2022 legislation that the representative has referred to modified, and I drafted that modification. That is the Personal Property Perpetuities Act. It was enacted in 2008, and it touches two acts, the acts affected by 4863 and 4864, namely the Powers of Appointment Act and the Uniform Statutory Rule against perpetuities. The latter was Michigan's initial modification of the common law rule against perpetuities. It was adopted in 1988. These three statutes work together. The confluence.
I'm so sorry. Can you explain the rule against perpetuities in a way that somebody who did not go to law school would understand?
Probably not.
Okay.
But that's not going to prevent me trying. You can't imagine, Madam Chair, how long I've waited for an invitation to attempt such a thing. My best attempt now is simply to say that the idea that property, and when the rule was given currency initially, it was judge-made law, and wealth was land. And the idea that land could be tied up indefinitely by someone who owned it at the moment, ownership being suspended until the deaths of people that owner, that planning person, will never know, because she wished to suspend ownership of land for 28, 30, 45 generations. That was thought to be bad policy. And judges tried to make rules that would allow someone who owned property to control what would happen with that property for a limited number of generations. And the idea of 21 years from the death of some life in being at the time the trust or other arrangement for the ownership of real property was created was thought to be a good limit, durational limit. That is the common law description based on measuring lives. So it has to be 21 years from the death of some life in being at the time I create a trust, that all of the interests in the trust will vest, such that we know who has the ability, even if it takes several people to do it, to sell the property. And the rule against perpetuities was designed initially to guarantee that. Michigan, through its modifications of the common law rule, legislative modifications, has a regime in which it is possible, by creating a trust, to suspend vesting of ownership in personal property, not real property, indefinitely. In Michigan, real property, which is part of the race, the corpus, the subject of a trust, has to vest within 90 years of the date the trust is created, or within 21 years from the death of some life in being at the time that trust was created. And that's the upshot of the Uniform Statutory Rule against perpetuities. I did it, didn't I?
Yeah.
I'm going to check the faces of my fellow committee members to see if they got it. Denied. Please continue.
Okay, thank you. These, compared to that description, these technical amendments are technical in a very simple sense. The technical amendments don't change the law in any way that would cause the result to be different if the questions they treat were before a judge today who knew the canons or rules of statutory construction. In other words, these bills affect statutes which, in their current form, under a knowledge of statutory construction, do get the right answer to all of the questions these bills anticipate. The problem is that legislative drafting that relies on rules of statutory construction assumes a fairly high standard of judicial culture, a standard that is, by and large, met in Michigan. We enjoy a high standard of judicial culture in this state. But to the extent that rules regarding trusts, powers of appointment, the rule against perpetuities become codified, become a matter of statute in a given jurisdiction, non-litigating attorneys, transactional attorneys, stop reading the cases. They expect the answers to be in the code they consult. And that means by not reading the cases, they don't see the tools with which judges work on questions that come before them because of a statute. They lose touch with the basic tools. From the point of view of the legislature's commerce with the courts, rules of construction are like grammar in ordinary speech. When you want to say something to someone, you don't tell them the relevant rules of grammar you're about to use and then say what you have in mind. You say it, and you assume they know, as competent speakers of the language, how to interpret what you've just said. The legislature does the same thing with the judiciary. When the legislature makes a law, it is understood that to the extent it is in a common law area, the law will be strictly construed. Unless you contradict the common law, the judges will assume that you haven't meant to change it. That's an example of a rule of construction that is well known to judges, less and less so to transactional as opposed to litigating attorneys, because they want to know what they need to know to do what they need to do for their clients from the statute that informs the documents they're going to create, the actions they're going to take on behalf of those clients. So what these technical corrections do is they make each of the affected statutes explicit on coordination between sections, between subsections, between statutes. A judge who knows what she's doing will know that the Personal Property Trust Perpetuities Act, the Uniform Statutory Rule Against Perpetuities, and the Powers of Appointment Act of 1967 are, quote, in pari materia. That is, they have to be interpreted together. They have to be interpreted to work together. Attorneys who are less familiar with that canon of statutory interpretation will regard contradiction or lack of coordination as an ambiguity in the statute. A judge doesn't read that as an ambiguity. A judge reads that as an invitation to apply basic tools of jurisprudence. Those basic tools are being codified here and made part of the statutes, the interpretation of which depend upon those tools. And that's what is done in two instances in each of the two bills. With respect to the Powers of Appointment Act, the idea of strict construction is applied in a very complicated context in which the common law notion that a trustee who has discretionary power to make distributions to beneficiaries can create trusts for those beneficiaries. That raises a question, can she create powers of appointment for those beneficiaries? And the answer at common law and in the statute is yes. Can she create a power of appointment in a beneficiary to whom she has the ability to make distributions to appoint to people who are not beneficiaries of the trust? Yes, at common law and under the statute. Can she give such a power to someone who's not a beneficiary of the trust? At common law, the answer is no, and for that reason, a judge asks that question. Does the statute allow a trustee to create a power of appointment in a non-beneficiary of the trust to appoint to people who are not beneficiaries? The judge will say no, because the common law doesn't, and a statute that changes the common law, that operates in a common law area, is strictly construed. What the bill 4863 does is puts into the statute the phrase reference to permissible appointees of the trustee's power and makes explicit what the judge would, the conclusion the judge would come to based on a rule of construction according to which legislation in a common law area makes the minimum change to the common law that allows the change to be intelligible. Likewise, the same bill, 4863, adds a subsection 4, a subsection 4 to section 14, and says expressly that the same convention regarding the effective date provision of the Powers of Appointment Act controls the Personal Property Trust Perpetuities Act and the Uniform Statutory Rule Against Perpetuities. A judge comes to that conclusion because those statutes are, quote, in pari materia. But the non-litigating, the practicing transactional attorney who is unfamiliar with that rule of statutory construction, now, when this bill becomes law, will have an express direction to think in those terms. Two very similar changes in Bill 4864, in this case to the statutory rule against perpetuities. There's a change to Section 3. Subsection 1 of Section 3 is codification of a common law principle to which subsection 3 is an exception. That exception is flatly contradicted by subsection 5, which refers to the Personal Property Trust Perpetuities Act. That flat contradiction is a signal to the judge that there's an exception for section 5, subsection 2, in this particular subsection. The practicing transactional attorney who operates without the benefit of familiarity with the rules of statutory construction is directed here to focus on the idea that there is an exception because statutes are read so as not to involve inconsistencies that threaten coherence. And again, the idea of strict construction is codified and applied to the Uniform Statutory Rule in the cross-reference in Section 5, subsection 2, to the Personal Property Trust Perpetuities Act. A judge would not need the cleanup in that cross-reference that was required by the 2022 legislation that Representative Wozniak referred to in his introduction. That's 2022 Public Act 154, which became effective on July 19, 2022. So those are 4 technical corrections created in the 2 bills before the committee today. And I'm at the committee's disposal if anyone wants either to ask a question regarding these bills or to have another attempt to formulate for non-lawyers the rule against perpetuities.
Can you just explain to us a practical example of what would happen if we do not make these changes?
Yes, thank you, Madam Chair. What will happen is the money will be spent to bring the question to court after a transactional attorney has made a decision, written a trust instrument, for example, that tries to avail of the Delaware tax trap which involves exercising a power of appointment so as to increase basis for determining gain for federal income tax purposes under a rule called the step-up rule in the federal estate tax. Michigan law is adapted to make people who are familiar with all those phrases that I just strung together to allow them to get good tax results for their clients through trust planning. But the use of a power of appointment will make the Powers of Appointment Act of 1967 and its interpretation crucial to the question whether the Delaware tax trap has been or has not been sprung. If a question arises as to whether PITPA and the and the Powers of Appointment Act are meant to work together to that end, a judge will know that the answer is yes. These statutes are in pari materia. They rely on one another for the sense they contribute to Michigan's legislative code. But those, the instruction to read them together, subsection by subsection, is not in the code now, and that means that the resolution of this will be from the bench. A judge applying the rules of statutory construction I was alluding to earlier will get the right result, but not before parties have spent the time and money required to ask the judge to interpret the statute. These technical amendments are an attempt to make the statute more self-interpreting from the point of view of a transactional attorney trying to use them for the benefit of that attorney's clients.
I think that last statement is what we needed. It will stop people from needing to go to court and spending time and money to resolve trust issues. Is that?
That is correct.
Okay.
And again, I want to emphasize that we're not changing the law. We are dispensing with the necessity of the knowledge a judge has in dealing with several statutes at once on such a complex area. The right answers are there in the code now, but only judges have the knowledge to pull it out competently time after time. This will make the statute, these changes will make the statutes more instructive for attorneys who want to use the statutes for their clients without going to court to make sure they've done it correctly.
Madam Chair, not to confuse the issue, but hopefully to clarify it a little bit. If you understand the terms of stepped-up basis as it refers to trusts,
Let's assume most people up here don't understand that.
okay. Stepped-up basis is when the value of an asset changes, say on the date of death or other chosen date, particularly when it's in a trust such as this. And then what these powers of appointment do is allow the assets to be transferred at some later date up to about 90 years. And then it's all got to go away. The other issue that people pay attention to is the estate tax exclusion. Let's say you die and you've got 12 million bucks. Well, right now, that estate tax exclusion, you don't have to pay any tax on it. So that is affected by these bills also. But that's going to change in what, 2025? Yeah, we might have to go back to reality after that. But those two things are incorporated in these two bills too, and how they get affected by the rule against perpetuities.
Thank you, gentlemen. Are there any questions from the committee? Representative Devendorf.
Hello, good to see you again. Would this legislation be a good complement to the partition of heirs legislation? Between the two of them, would they be closing some necessary questions?
No. The province of these acts are so different. It is conceivable that someone's tax plan could have involved the idea that a very small percentage ownership in some real estate, a farm, an urban lot that is being operated as a parking lot, could be involved. But that is as random an event as having an apartment building somewhere owned wholly by the estate planning, the person who sought the advice of an estate planner. So the Partition of Heirs Act is a very important uniform act designed to help states protect small holders, holders of very small interests, from exploitation by developers and people who want to obtain large plots of land for substantially less than those plots are worth. And families lose control of important family assets in the way of real estate in a way that is directly treated by the Partitions of Heirs Act. These acts, Representative, affect aspects of the law that are much older than the developer exploitation tack that the Partition Act is meant to meet and thwart.
Just as a follow-up, it seems like a number of these policies, we are looking at the inexactness that can occur when property is handed down. Is this related at all, and it may not be in the slightest, to lack of education on estate planning and financial literacy and the combination of all of these things together, and or access to an attorney?
That question, the answer to that question tends to your interest in the Partition Act at that level of planning, as opposed to the level of tax planning that Representative Wozniak was just describing. But at the level of planning, what's going to happen when Grandma dies to the old homestead, it's lack of access to legal information, and I'm not sure how much of it has to be provided by an attorney, but attorneys, to be frank, operate as a monopoly, and they have an interest in conservation of knowledge. The conservation of knowledge affects people in markets that monopoly is not serving. But here, Representative, we are very much talking about policy dynamics that affect, for example, the segment of society that is addressed by the Partition of Heirs Act, and not the Delaware tax trap and the kind of planning facilitated by Michigan's Powers of Appointment Act, the Uniform Statutory Rule Against Perpetuities, and the Personal Property Trust Perpetuities Act. Thank you.
Any other questions from the committee? Okay. We have, the only card we have here is from Mr. Spica. And I believe we will be voting these out next week, and where we will, again, likely be bringing up xylazine and drug immunity. I don't believe we have anybody else wishing to speak today, and seeing no absent members and no further business before the committee, we stand adjourned.